My name is Father Don Anstetter. I'm the Director of Worship here at Kenrick-Glennon Seminary, and it's my honor on behalf of Father Mason, the rector of this institution, to welcome all of you here to the seminary, to this, the 21st Annual Peter Richard Kenrick Lecture. And this lecture is possible because of an endowment that was the gift of the graduating class of 1944 to the seminary, an endowment that was intended for the continued formation of priests, seminarians, and those who serve the church. And so it's a great honor that we are able to continue this venerable tradition. And now I'd like to invite forward Monsignor James Ramacati to introduce our presenter for this evening. Monsignor?
Thank you, Father. Good evening, everyone, and welcome. Last evening, Kenrick-Glennon Seminary hosted its annual alumni banquet and awards presentation. And at the conclusion of the evening's festivities, the Master of Ceremonies announced upcoming events occurring here at the seminary. He announced that tomorrow night, tonight, would be the 21st Annual Peter Richard Kenrick Lecture, and he announced with his tongue firmly in his cheek that the lecture would be on the thrilling topic of canon law. Now, I happen to believe that the science of canon law is thrilling. It's exciting. It's exciting because the subject matter is exciting. The subject matter is about the body of Christ, the church, the people of God. The science of canon law is a pastoral enterprise, as St. John Paul II so succinctly pointed out, to strengthen the bonds of communion among the members of the church, so that each member can come to a deeper understanding of his or her role as a member of this society, understanding his or her rights and obligations in the context of the church. The aim of canon law, the very objective of canon law, is, as Canon 1752 declares, salus animarum, the salvation of souls. That's exciting. That's thrilling. Today there are provocative questions, unforeseen challenges regarding the application of law and indeed the very meaning of the law to particular circumstances and situations, about which our father in faith, Gratian, could never ever have imagined. The church needs, and indeed the people of God are owed, scholarly, sagacious canonists imbued with a pastoral heart. We are so honored and fortunate at Kenrick-Glennon this evening to have such a canonist in our midst as our featured speaker. Archbishop Hebda was ordained to the holy priesthood for the Diocese of Pittsburgh on July the 1st, 1989. He engaged in pastoral work before embarking upon his studies in canon law. In 1990, he earned his degree in canon law from the Pontifical Gregorian University in Rome. In 1996, he was appointed to the Pontifical Council for the Interpretation of Legislative Texts, which is the Roman dicastery charged with authentically interpreting the laws of the Church, and in a particular way, the canons of the Code. In 2003, Pope John Paul II appointed him the Undersecretary of that dicastery. Pope Benedict XVI appointed our featured lecturer to be the fourth bishop of the Diocese of Gaylord, Michigan, in October of 2009. He received episcopal consecration on December the 1st of 2009. Bishop Hebda was appointed coadjutor Archbishop of Newark by Pope Francis in 2013, and on March 24th, 2016, Archbishop Hebda was appointed to shepherd the Metropolitan See of St. Paul in Minneapolis. Indeed, it is a unique honor and a privilege to introduce as our 21st Annual Peter Richard Kenrick Lecturer, His Excellency, Archbishop Bernard Hebda.
Thank you, Monsignor. Did you say sagacious or salacious? I wasn't sure. It's really frightening to have to give this talk after a wonderful dinner. And I've been given instructions that it's supposed to be academic and about canon law. They were basically the parameters. And so what follows is my fault, not Monsignor's, for sure, or Archbishop Carlson's. But I wanted to speak this evening a little bit about the topic of our present Holy Father, Pope Francis, as a legislator, and the way in which he uses law to advance reform and renewal. And so that's essentially what I'm going to talk about. One of the dangers of being a canonist, though, is we always kind of start with Adam and Eve. We go back to the very beginning. So I apologize, it's just the way I am. In our American system, so you know from grade school that we always talk about three branches of government. The executive branch, the judicial branch, and the legislative. In the church, all three of them converge in the person of the Holy Father, of the Pope, the Bishop of Rome. He has the power of governance, of judging, and of legislating. Canon 331 of the Latin Code says this: "The Bishop of the Roman Church, in whom continues the office given by the Lord uniquely to Peter, the first of the apostles, and to be transmitted to his successors, is the head of the College of Bishops, the vicar of Christ, and the pastor of the universal church on earth." And then it says this: "By virtue of his office, he possesses supreme, full, immediate, and universal ordinary power in the church, which he is always able to exercise freely." You might remember from Mel Brooks's The History of the World, there's the line that says, "It's good to be king." Well, it's even better to be pope, huh? Unlike the American system, there is no way, for example, that the Pope could promulgate a law and have it overturned by a court, since the Pope himself is not only the supreme legislator, but is also the head of all church courts. That doesn't mean, however, that there are no limits to his authority. He is unable, for example, to contradict anything that is recognized as divine law. He legislates in a number of different arenas. He legislates, for example, for Vatican City-State, that the small territory there in the middle of Rome. He legislates for the universal church of which we are part. He legislates for the Holy See, entering into concordats and agreements with other nations. Tonight, we're not going to be looking very much at Pope Francis's legislative activity in the sphere of Vatican City, and we're not going to be looking at his activity in the sphere of bilateral or multilateral treaties or concordats. We're going to be looking primarily at how he affects the universal church through his legislative activity. For the most part, we will be speaking about the areas covered or related to the Code of Canon Law or the Code of Canons of the Eastern churches. Even from the secular perspective, stability and predictability are characteristics or hallmarks of a good law. Indeed, as noted by law professors at the University of Texas, Lindquist and Cross, legal stability and predictability are a fundamental part of what people mean by the rule of law. They cite Eskridge and Fricke for the proposition that in the absence of stability and predictability in law, citizens have difficulty managing their affairs effectively. Legal stability also has a moral valence, insofar as it assures that like cases will be treated equally. From a technical point of view, laws should be drafted carefully enough that they shouldn't require amendment, certainly not frequent amendment. In the church, the first codification of the law took place in 1917, a monumental undertaking, and it wasn't revised until 1983, more than 65 years without serious amendment to the essential, to the basic code. And that was really seen then as an indication of a well-crafted law, that it could continue to be relevant for so long. When St. John the 23rd set into motion the Second Vatican Council, he recognized that that would require a revision of the Code of Canon Law. And that work began on the revision right after the Council, 18 years before the new code would be promulgated. In part, it took a long time to revise the code because of a need to let the dust settle a bit after the Council. But the amount of time also reflected how important legislation is. Those who were drafting this legislation needed to get it right. To maximize the probability that they would be getting it right, the Commission for the Revision of the Code engaged in extensive consultation that involved both experts and pastors. They wanted to make sure that the law would be correct. It took years to revise the code, as I said, with that universal consultation of experts and pastors. And once the law was in place, there was understandably a reluctance to revise it. The Code of Canon Law itself, however, includes a mechanism that allows the law to breathe, a canonical institute called authentic interpretation. Usually, what happens is that they pose a yes or no question, and with that response, yes or no, having the force of law. And while there is a reluctance to revise the law too often, it was always foreseen that the legislator, in this case the Pope, could from time to time supplement the law with additional legislation, or allow the offices of the Curia to promulgate regulations concerning how the canonical norms were to be applied. When asked to do so, the Pontifical Council for Legislative Texts, where I worked for 13 years, would assist the Holy Father in promulgating legislation. It was an earlier iteration of our office that had been involved in the promulgation of the Code of Canon Law, and we were regularly involved in assisting the offices of the Curia when they would be issuing documents with a normative content. It made sense that we would be involved in assisting the Holy Father with legislation, and I believe that it was a substantial help to him, in part because at least our recent popes haven't been canonists by training. As a result, the popes, even the popes, seem to be a little afraid of canon law, of legislation. While Pope Benedict was a great theologian, I think he really at heart had a canonist's eye. He was really attentive to detail, to the fine print. When we would give him a draft, we would get back comments from time to time in his tiny handwriting, and he would always be right on target. On the occasion of the 25th anniversary of the Code of Canon Law, Pope Benedict spoke profoundly about law in the Church. He addressed obliquely the need for stability and addressed directly the need for flexibility. In particular, he spoke of a need to take stock of the canons to see how they were serving the Church at the modern time. He noted that it would be necessary to abrogate norms that prove antiquated, to modify those in need of correction, to interpret in light of the Church's living magisterium those that are doubtful, and lastly, to fill possible lacunae legis, to fill any gaps that might exist. I was working at the Pontifical Council for Legislative Texts at that time. We saw Pope Benedict's comments as a green light for undertaking a fairly extensive updating. Not long after Pope Benedict spoke about plugging the lacunae and addressing norms that might be in need of correction or revision, the Pontifical Council set up 4 working groups. One of them had to do with revising procedures for the declaration of nullity for tribunal procedure. Another had to do with revising the penal law of the Church. Another had to do with harmonizing differences between the Latin law, the law for the Latin Church and the law for the Eastern churches. and a fourth working group was putting together norms to govern organisms of charity, how it is that we in the church were called to exercise charity. It was, however, a very slow-moving process, and that's often the case in the church. What we did is we appointed a working group of scholars for each of those 4 areas, and we tried to make them as representative as possible. But because they would be working frequently, we tried to draw them from the Roman universities. If you can imagine, there are 8 faculties of canon law right in the city of Rome. And besides those members of the working group, they would be assisted by the staff of the Pontifical Council, also drawn from in an international setting. Beyond those who were working just in the council or with the working group, we also had the advantage of a large group of consultants from all over the world who once again were representative of different cultures and also had different areas of expertise. Some would have been professors, some would have been involved in tribunal ministry, some would have been pastors. And then beyond that group of consultants, there was a group called the members of the Pontifical Council, and they would have been a group of cardinals. There was only one exception, and he happens to be an American. The Archbishop of Newark, Archbishop Myers, is a member. And it would be those members who would be the final arbiters of any proposal that would come forth. As I mentioned, in discussion with Pope Benedict, the Pontifical Council had formed those 4 working groups or task forces. But the process took so long that the Pope Benedict had actually resigned before 3 of the 4 topics ever saw the light of day. The only legislation that resulted prior to his resignation was the Motu Proprio Intima Natura Ecclesiae on the service of charity in 2012. The other 3 groups continued their work under Pope Francis, and just a few weeks ago, we finally saw a legislative document harmonizing the law for the Latin Church and the laws for the Eastern churches. All of that is background and context for what I really want to speak about this evening. When Pope Francis was elected, as you may remember, he was facing a number of hot-button issues. First of all, at least according to the press and to the cardinals who spoke at the sessions right before the conclave, the number one priority was the need for a reform of the Curia. How do we deal with scandal? How do we improve transparency? Second hot-button issue was accountability, whether that would be financial accountability or holding bishops accountable for their actions. A third area, a hot-button issue, was how do we promote a renewed sense of subsidiarity, shifting away from a tendency to centralization in Rome. And that would have bearings, as we'll discuss later, on ecumenism, for example. And then the fourth issue was how it would be that we could re-energize or reboot the church's relationship with the modern world. How is it that we keep the church always faithful to her teachings, relevant to the world? How is it that we use the media? How is it that we use communications? So those 4 hot-button issues would be issues that I think Pope Francis has addressed in his legislation since that time. But he also had some issues that concerns that were very particular to him that we hear about time in and time out. For example, in his talk before the conclave, he addressed the importance of being really attentive to the needs of the poor and the marginalized. You might remember that at his first audience with the press, right after he was elected, he spoke of his desire that we would be a poor church for the poor. The Mass at the beginning of his pontificate, the first Angelus audience, spoke about those themes of mercy, attentiveness to those on the periphery, access to all, the notion of accompaniment, the importance of collaboration and consultation, and certainly, as we've been hearing so much in this year, mercy. I would argue that in some ways, Pope Francis has utilized his legislative authority to address all four of the hot-button issues, as well as to address those overarching themes that have been so important in his pontificate. He seems to have an instinctive sense of the potential for achieving his objectives through legislation, even though he's not a lawyer. As we will be discussing this evening, I would consider it pretty phenomenal that he has had such legislative success in a relatively short period of time. Remember my comment earlier about how slow-moving the process for the revision of law normally is. One more preliminary remark. The popes normally legislate through two types of documents. The first is something called an apostolic constitution, and the second is an apostolic letter motu proprio. Apostolic constitutions are generally considered more formal, whereas motu proprios are a little bit more like executive orders. There's no hard and fast rule for which form legislation would take. If you go on the Vatican website and you click on the picture of Pope Francis, you'll see headings for both apostolic constitutions and motu proprios. All but one of the apostolic constitutions concern the erection of new dioceses or the reconfiguration of dioceses. The one exception is a document on women's contemplative life that we'll discuss a little bit later. There's nothing particularly notable about the listing of apostolic constitutions. When you go, however, to the listing of motu proprios, it's an unusually long list for a pope of only 3 years. 13 are denominated apostolic letters motu proprio, and 4 are entitled statutes. Motu proprio just means it's on the pope's own initiative. They range from the motu proprio setting up the new dicasteries of the Holy See and the statutes governing their operation, to the motu proprios overhauling marriage tribunals or establishing a procedure for holding bishops accountable for abuse of office. We'll be talking about the content of those documents in a moment. In addition to those strictly legislative documents, there has been one additional legislative action in Pope Francis's pontificate that affects the universal church. Just a few weeks ago, an authentic interpretation of Canon 1041, which concerns irregularities for the reception of holy orders, was published, and that has the force of law. While it was published by my old office, the Pontifical Council for Legislative Texts, its legislative significance really depends on the Pope's decision that an authentic interpretation be published. While it is technically an action of the Pontifical Council, it depends on an action of the Holy Father. So I think that it deserves mention. Before we look at the substance of any of the individual documents, allow me to make a few points concerning the interesting way in which those legislative documents were formulated, the methodology that was followed in arriving at the texts. Historically, drafts of legislation would arrive at the Holy Father's desk from one of the congregations or tribunals of the Holy See, or perhaps from my old office, the Pontifical Council. If I were to guess, a draft of the Apostolic Constitution on women's contemplative life was indeed probably generated by the Congregation for Institutes of Consecrated Life. They probably would have collaborated with the Pontifical Council and the Secretariat of State in preparing a draft for the Holy Father's decision. Similarly, the motu proprio that dealt with harmonizing some discordant norms in the Latin Code and the Code of Canons for the Eastern churches, we know that came out of the Pontifical Council, surely working with the Congregation for Oriental Churches and the Secretariat of State. That's the normal path and process. The bulk of the motu proprios that have been issued by Pope Francis, however, have followed a very different path. Shortly after Pope Francis was elected, you may remember that he established an advisory council of cardinals, one from each continent or region, that would meet periodically with Pope Francis to discuss things that he considered important. The group was affectionately known as the C8. Based on the press releases that would accompany their meetings, it would seem that it was this informal group that was the prime mover in the legislation creating each of the new dicasteries, the dicastery for promoting integral human development and the dicastery for the laity, family, and life, as well as the Secretariat for Communications and the Secretariat for the Economy. You find reference to that even in some of the motu proprios themselves. They make reference to the Pope having conferred with the Council of Cardinals. What's interesting about the C8, now expanded to the C9, is that the members were drawn from outside the Roman Curia for the most part. They are pastors and not bureaucrats. While a few have background in canon law, that's certainly not why they were chosen. Representing the United States, for example, is Cardinal Sean O'Malley from Boston. He never worked in Rome and had been spared from having to study canon law. His training was in Spanish and Portuguese literature. You can't get any more outside the ecclesiastical beltway than that. Huh? This group of cardinals approached the project of curial reform with pragmatism, trying to get a job done rather than trying to put together a beautiful, all-encompassing legislative framework for the Curia. The result is that they were able to act more quickly and more strategically, allowing then Pope Francis to act more quickly and more strategically. Since 1988, the structure of the Roman Curia has been determined by a document, an apostolic constitution, promulgated by St. John Paul called Pastor Bonus, the Good Shepherd. One of my former bosses had been one of the principal architects of that legislation, and he frequently bragged about the technical excellence of the document, rooting the structure of the Curia in our Catholic theology and providing for an all-encompassing structure. It took them, however, years to formulate the draft. And I think they were single-handedly responsible for killing whole forests of trees in the process. The archival file was immense. They wrestled with the fine points of the law, drawing distinctions, for example, between the different entities of the Curia, congregations, pontifical councils, tribunals, and commissions. They put together a whole skeleton for the Curia, and everything hung together nicely. The activity of the C8, in contrast, has been more akin to assisting Pope Francis in removing a ruptured appendix or replacing a hip. It's a very different approach that has enabled Pope Francis to have an immediate impact, the impact that I think he intends. A similar approach was taken to deal with what some perceive to be inefficiencies and challenges in our marriage tribunals. You may remember that I had mentioned that a working group had been set up in my old office to allow for some streamlining in the annulment process. It had already been working for 5 years at the time that Pope Francis was elected, and it continued its work during his pontificate. It came as a surprise, however, in September of 2014, on the eve of the first 2 synods on the family, when it was announced that the Pope had set up a special commission for the study of reform of the canonical matrimonial process. No mention was made of the existence or work of the working group that had been laboring on this project for 6 years. And to the best of my knowledge, the commission that the Holy Father set up and the working group that had been in my office only shared 1 member in common. Once again, showing that he didn't feel bound by protocol, Pope Francis named as head of that commission Monsignor Pio Vito Pinto, the Dean of the Rota, even though the commission included a cardinal and an archbishop. That certainly caused eyebrows to go up. Amazingly, just 1 year later, Pope Francis issued a motu proprio based on their work, unheard of for a project to reach its conclusion so quickly. We'll speak about its substance a little later, But at this point, I just wanted to emphasize that the Pope got a huge win in record time, going outside the traditional curial structure, and for the most part relying on experts who weren't on the list of usual suspects. Let's now turn our attention to the substance of Pope Francis's legislative initiatives, recalling those hot-button issues that I mentioned earlier that he was facing at the time of his election. You will remember that the top two seem to be curial reform and accountability transparency. If the Vaticanisti were correct, the cardinals who had traveled to Rome for the election of the new pope had put curial reform high on their agenda. They spoke of a system weakened by turf protection and siloing, a bureaucracy that was too big for coordination and unable to collaborate. They repeated the refrain that the message that the Curia was supposed to help rather than hinder bishops and local churches from around the world had somehow been lost. They viewed the system as having run amok, with such little oversight in the areas of budget and decision-making that it provided a recipe for disaster and corruption. They also spoke about the reach of the Secretariat of State, which in some ways duplicated the work of all of the other Vatican offices. To address this situation, Pope Francis turned to his kitchen cabinet, the C8, to draft a reform of the Apostolic Constitution Pastor Bonus that I mentioned earlier, which would regulate the Curia, and to make it an apparatus that was streamlined, more efficient, less expensive, and more collaborative. Recognizing the enormity of the project, the C8, working in collaboration with the Holy Father, decided to eat the elephant one bite at a time and to tackle the issues piecemeal. The first bite was in the area of economic and administrative affairs. 11 months into his pontificate, the Holy Father issued the motu proprio Fidelis Dispensator et Prudens, the faithful and prudent administrator, establishing a new economic administrative structure for the Holy See. The new law established a 15-member Council of the Economy with oversight for the administrative and financial structures and activities of the dicasteries of the Roman Curia and institutions otherwise linked to the Holy See and a Vatican city-state. Now, of those 15, 8 were to be drawn from cardinals and bishops, reflecting the Catholicity of the Church, read that as international, and 7 being lay experts of various nationalities and recognized professional financial competence. That same legislation created a secretariat for the economy, directly responsible to the Holy Father, and competent for economic control and vigilance. The Secretariat was given a broad competence with special mention of purchasing and of the allocation of human resources, in particular of hiring. The Secretariat would be headed by a cardinal prefect who was to act in collaboration with the Secretariat of State, who in many ways is seen as the number 2 in the Vatican structure. The law also noted that the Holy Father would be appointing an auditor general to audit all of the entities that were mentioned above. The law was really the first tip-off to Francis's gift as a legislator. The law revealed an ability to recognize priorities and to be creative in moving with the speed required for real reform. Had he waited for an overall reform of the Curia, as had been the case when Pastor Bonus was being prepared and when it was promulgated, we would still be waiting. Pope Francis used the legislation to show his hand as one interested in more than theoretical reform. Normally, when an organization is created, part of the rollout is the promulgation of the statutes governing how the organization is to run. In this case, however, rather than waiting, Pope Francis created the Council and Secretariat and Auditor General and charged the Secretariat with preparing definitive statutes that were to be presented quam primum, as soon as possible, to the Pope for approval. From a technical perspective, the law was bare bones, but it gave the Holy Father a structure that would help in reforming the rest of the Curia, providing him with the economic data, for example, that he would need, or the personnel data that he would need. The structures that he created in that first piece of legislation reflected his emphasis on consultation, on internationalizing the Curia, and on making it less clerical. Recall that 7 of the members of the Council for the Economy are to be lay experts with recognized professional financial competence. The law also served his purpose of relating better to the outside world, communicating that he was more interested in competence than privilege, and opening the Curia to secular best practices and fostering transparency. By means of that piece of legislation, the Pope also managed to respond to those who thought that the Secretariat of State was too influential. By creating another secretariat, the Holy Father had made the Secretariat of State less singular. Also of significance in this regard would have been the specification that the new Secretariat was directly responsible to the Holy Father, which was novel in that the previous model for the Curia would have had the organization under the direction of the Secretary of State. While not directly related to our topic today, the Pope solidified the impact of the legislation by means of his choice in hiring. He named as the first cardinal prefect of that secretariat Cardinal Pell from Australia, a diocesan bishop rather than a curial cardinal, outside the proverbial beltway, whose size and demeanor reflect his former prowess as a rugby star. He's used to brawling. As the first general secretary, the number 2 in that structure, the Pope named his own personal secretary, a very competent, no-nonsense Maltese priest, Monsignor Alfred Schwereb. As the first secretary for the Council for the Economy, he named Monsignor Brian Firm, another Oxford-educated Australian and a former lecturer for this lecture. None of the 3 would be beholden to anyone other than Pope Francis. Since that time, the Pope has gone on to create 3 other new structures in the Curia. In June of this year, with a motu proprio entitled The Current Context of Communications, Pope Francis established a new secretariat for communications, effectively bringing into one office the work that was previously done by 6 independent entities: the Pontifical Council for Social Communications, the Vatican Press Office, the Vatican Press and Bookstore, Vatican Radio, CTV, the Vatican Television entity, and the Internet Office. The consolidation should allow for much greater coordination and the evaluation of its effectiveness. The statutes for the new Secretariat were promulgated just on the 6th of September. In addition to that Secretariat, on the Feast of the Assumption this year, the Pope issued a motu proprio establishing a new dicastery for the laity, the family, and life. Consolidating the work was formally engaged by the Pontifical Council for the laity and the Pontifical Council for the family. He has called our own Bishop Kevin Farrell of Dallas to Rome to head that new office. Once again, it's someone from outside the usual curial structure. And just 2 days later, he issued a motu proprio instituting a dicastery for promoting integral human development, which had the effect of consolidating the work of what had been the Pontifical Council for Justice and Peace, the Pontifical Council for Migrants and Tourism, the Pontifical Council Cor Unum, which is the office that serves as a vehicle for the Pope's relief efforts around the globe, and also the Pontifical Council for Healthcare Workers. The new office will have a broad portfolio. It will be competent in issues regarding migrants, those in need, the sick, the excluded and marginalized, the imprisoned and the unemployed, as well as victims of armed conflict, natural disasters, and all forms of slavery and torture. It has rightly been called a super dicastery. While the new prefect already has curial experience, Cardinal Turkson, he's been the president of the Pontifical Council for Peace and Justice, he's also a bit of an outside the beltway type in that he's from Ghana, and he wasn't a Vatican careerist. He's a scripture scholar by training with experience in pastoral ministry. Maybe Father Swettenham taught him, I'm not sure. Statutes for both of the new dicasteries were promulgated at the same time that the motu proprio creating the dicastery was released. Once again, the motu proprios were bare bones, barely a page, but effective, not only in establishing the new dicastery, but also suppressing the former offices. To allow for flexibility, growth, and development, the statutes for those new offices were approved ad experimentum, avoiding the delays that would have necessarily accompanied the promulgation of more permanent statutes. Allow me to get into the weeds a moment concerning the statutes of the dicastery for promoting integral human development, because I think they are brilliant in allowing for a merger of 4 previous entities without creating the impression that any of the previous focuses or emphases were being downgraded. The statutes specify that there will be a special section within the dicastery that will oversee matters concerning refugees and migrants, which will, at least for the moment, be under the guidance of Pope Francis himself. The statutes also specified that there will be commissions constituted within the dicastery for charity, for ecology, and for healthcare workers. The statutes, moreover, spell out an expectation of collaboration that is both internal and external, that really gets to the issue of siloing. Please allow me to offer 2 further observations. The first has to deal with titles. Of the 4 primary structures created by Pope Francis, 2 are called secretariats, economy and communications, and 2 are given the generic designation is dicastery. I don't think that is by chance. In the structures that existed under Pastor Bonus, there was a bit of a hierarchy, with congregations being ahead of pontifical councils. Congregations were seen as structures of governance and were ordinarily headed by cardinals. The pontifical councils were seen as structures of study and advocacy or promotion and were only sometimes headed by cardinals. While I have no idea if the Pope intends to keep the names given to the new offices, the use of the generic dicastery or the novel secretariat steps aside from the pecking order in a way that could promote more effective collaboration within the Curia. In the present structure, moreover, there was a bit of a glass ceiling for laity and non-ordained religious. It remains to be seen what will transpire in the new dicasteries. Bishop Farrell has already hinted at lay leadership at the highest level in his new dicastery for the laity. That would certainly favor what Pope Francis has been saying about the role of women in the church and about expertise being more important than privilege. My second observation also concerns leadership, but from a slightly different direction. One of the observations that was made at the time of the last conclave electing Pope Francis was that the number of cardinals coming from the Curia and related positions in Rome was grossly disproportionate. Almost 1/4 of the voting cardinals would have been from Rome. In the consolidations that have taken place as a result of Pope Francis's legislation, there are now already 4 fewer potential slots for cardinals. That would seem to be already significant. What about the other hot-button issues? While the curial restructuring, and particularly the creation of the Secretariat for the Economy, addresses transparency and financial accountability, Pope Francis has moved decisively on the accountability front by means of his motu proprio as a loving mother, which was promulgated last June. While it can be traced in part to the C9, it was also influenced by the Vatican Commission on Child Protection, which is chaired by Cardinal O'Malley, and which itself is a product of the C9. In a nutshell, that new legislation, short and to the point, makes it clear that a bishop can be removed from office if he has through negligence committed or through omission facilitated acts that have caused grave harm to others. While a bishop can generally be removed only if he is objectively lacking diligence in a very grave manner, that standard is reduced from very grave manner to simply a grave manner if the person who is harmed is a minor or a vulnerable adult. The legislation then proceeds to lay out an administrative procedure for judging whether an accused bishop should be removed. The process is noteworthy because, once again, it reflects Pope Francis's emphasis on consultation. The relevant congregation is invited to discuss the case with other bishops from the accused bishop's region and country. And in the event that the Pope would receive a recommendation that the bishop was indeed to be removed from office, the Pope is instructed to take counsel with a special college of jurists designated for this purpose. For Pope Francis, consultation is crucial. The legislation has been criticized by some for giving the accused bishop an out by allowing him to resign rather than be removed. But the motu proprio has otherwise been praised as a practical means for dealing with a very difficult and delicate situation. Interestingly, the Pope had initially announced in 2014 that these cases would be decided by a tribunal that he would be setting up in the Congregation for the Doctrine of the Faith. But the Pope changed the modality once it became clear that a tribunal of that sort was unworkable. I found it interesting and refreshing that the Pope would be responsive to the feedback that he had received and would move from a judicial proceeding to an equally serious administrative process. The development emphasizes how practical Pope Francis is as a legislator. His focus on getting something done well, in this case ensuring accountability, even if he was left with a little bit of juridical egg on his face, still carried the day. Another of the hot-button issues was subsidiarity and centralization. How much leeway should those on the local scene be given to come up with solutions versus how much should matters be determined in a centralized way in Rome? This has ramifications not only for us within the Church, but also in our ecumenical endeavors, with our Protestant or Orthodox brothers or sisters having a stronger tradition of local decision-making. In this optic, the Pope's recent motu proprio on harmonizing the code for the Latin Church and the code of canons for the Eastern churches has more significance than might appear at first blush. It gets into the details of requirements for the validity of a marriage. The Eastern tradition, for example, doesn't foresee deacons officiating at weddings, and then also explores the consequences of baptism. Those who are expert in these things saw the new law as sending a powerful message that the Catholic Church is a communion of co-equal sister churches with their own rich rights and traditions deserving of mutual respect. The new legislation shows a real respect for the venerable Eastern rites, which are part of the patrimony not only of the Eastern Catholic churches, but also of the Eastern Orthodox churches. The law was also favorably received as a manifestation of Pope Francis's concern for refugees. I don't know the present situation here in the Archdiocese of St. Louis, but in most parts of the United States, our contact with the Eastern churches was mostly through the Maronite, Ruthenian, or Ukrainian churches, which are pretty well established in the United States. Now, however, the situation in the Middle East has resulted in large numbers of Coptic Christians and Syriac Christians, Chaldean Christians fleeing their homelands and heading to countries such as the U.S., where their church's presence has been much less developed. So more and more Latin Rite churches are dealing with Eastern Catholics from those churches. For Pope Francis, I would suspect, showing increased respect and hospitality to these Eastern Christians would not only speak to subsidiarity, but also to the Church's care for those who were poor and on the periphery. Walking the fine line between centralization and subsidiarity would also be reflected in the Apostolic Constitution concerning women in contemplative life, issued earlier this year. After putting forth a couple of models of contemplative life, Pope Francis calls upon the sisters to choose one of those models, to make their own determination at the local level, and then to communicate that to Rome. That's subsidiarity in action. The legislation also gives more authority to federations of sisters in one tradition, so a federation of Benedictines, or a federation of Franciscans, or a federation of the Visitation Sisters, and then includes them in the process, for example, of trying to decide what to do when a community shrinks to the point that it is doubtful that it could continue. The Congregation for Consecrated Life in Rome is still involved in making decisions, but there's a notable emphasis on more localized decision-making. The fourth and final of the hot-button issues that I had mentioned earlier concerns how we reboot or reframe our engagement with the world, being true to who we are, but trying to address real-life experiences of those who are seeking meaning or who have drifted from the church. It's more a question, I would guess, for communications than for canon law. But I think that Pope Francis has even used his legislative authority in a way that causes folks to take another look at the church and her teaching. I have in mind the two pieces of legislation, one for the Latin Church and one for the Eastern churches, that have generated lots of press, but taking on head-on the challenges of our tribunal procedures for annulments. Pope Francis recognizes in both of those documents that the issue of the church's engagement with those who are divorced and remarried is fertile ground for the new evangelization. So many of our brothers and sisters have stopped coming to church because of the church's fidelity to Jesus' teaching on the permanence of marriage. While our response has always been to encourage people to pursue a declaration of nullity, the all too frequent rebuttal has been that the process is painfully long, invasive, confrontational, and expensive. With the two new laws and the revisions that they enact, Pope Francis wants to change that discussion. While being faithful to the teachings of the church, there's a desire on his part to respond legislatively to the critique that the process is long, painful, and expensive. He introduced, for example, the possibility of abbreviating the process and shortening the ordeal by eliminating our requirement that all decisions would be reviewed in a second instance by an appeals tribunal, even if the parties weren't interested in an appeal. His new legislation expresses a preference, moreover, for the elimination of the cost factor, and he calls for an approach that is less adversarial and more pastoral. It should be more one of accompaniment. His call for the individual bishop to become involved, while problematic and challenging in some respects, can be expected to give the bishop a greater exposure to the pain of those who have experienced the breakdown of their marriages, hopefully prompting the bishop to place excellent personnel resources in this important ministry. Judging from the number of folks who have approached our tribunals since those two pieces of legislation were promulgated, the Pope was very successful in getting people to hear of the Church's constant pastoral concern for those who are divorced and remarried. Given the haste with which it was drafted and promulgated, it would probably not win any awards for legal precision. and has required, in fact, some clarification. The time that it would have taken, however, to make the law perfect militated against that effort. I think that it is one of those situations where better was truly the enemy of the good. Recall that the working group in my old office had been working for 7 years without a positive result. By choosing another process involving a different group of people and adapting a different style, Pope Francis has managed to re-engage a whole sector of our population for the good. That's pretty humbling when you think that that was all accomplished by a non-canonist pope. I can see that I've been talking already too long, so I'm going to stop, but we have the opportunity now for some questions and for some comments. Thanks.
Archbishop Hebda, and we thank you for giving us this wonderful insight into the workings of the Holy Father's mind and his legislative efforts, but through the lens of both a canonist and a pastor, which is very evident in your remarks. And so we thank you very much for that. And now I ask Archbishop Carlson here, who is the chairman of the board of directors for Kenrick-Glennon Seminary, to give you this memento of our gratitude for this talk that you've given us tonight. So thank you very much for everything you've done.
Thanks.
Immediately following this, there will be a coffee reception up in the corridor just outside the auditorium, to which you are all welcome. So please enjoy yourselves. And this concludes our program for the evening. Thank you.